is a public hearing relating to the redetermination of electricity tariff applications for Madibeng and the city of EKURHULENI for the financial year 2024-25. My name is Nomalanga Sitole. I was trying to open my camera, and I will be the chairperson of this hearing, and I would like to introduce Mkhize, who is a member of the energy regulator and a member of this panel. And Mr. Mkhize, you may greet the attendees. Over to you, sir.
Thank you, Chairperson. Good morning to you, Chairperson, fellow members of the panel, as well as everyone that is on the call. Thank you.
And thank you very much. And I'll proceed to Mr. Willie Broad Majola, who is also a member of the energy regulator and a member of this particular panel. Mr. Majola, you may proceed to greet the attendees.
Good morning, Chair, and good morning to the members, and also good morning to all the members of the public that are joining us for this hearing. Thank you very much, Chair.
And thank you very much, Mr. Majola. And then I'll proceed to Ms. Nomfundo Maseti, who is a member of the energy regulator and a member of the panel of this hearing. Ms. Maseti, over to you. You may greet the attendees.
Good morning, Chairperson, members, staff of NERSA, as well as the members of the public that have joined the hearing proceedings today. Thank you.
Thank you, members. And may I indicate that this hearing was duly advertised in the Brits Post EKURHULENI News, Netwerk 24, the Cape Times, the Mercury, the Star, Business Day, NERSA website, and NERSA social media platforms. This hearing is held in accordance with the Energy Regulator Act, and in which affected or interested parties are given an opportunity to submit their views and present relevant facts and evidence to the energy regulator. The hearing is governed by NERSA rules on public hearings, which can be summarized as follows. All parties will be required to make their presentation under oath. Presenters have been allocated 20 minutes each, and there'll be 10 minutes allocated to the members of the panel to ask questions or issues of clarity, and only members of the panel may ask questions to presenters. However, members of the public who may have any questions or issues of clarity, they are requested to submit those to the public hearing at nersa.org.za. I'll repeat the email. The email address is publichearings@nersa.org.za, and the panel will decide on how to deal with those questions. Should the presenters wish to present information they consider confidential, the panel will make a ruling on whether to close the hearing or have the information submitted in writing. And I must also indicate that the recording of this hearing, which is recorded via microphones, will be the official record of this meeting. Moving on to House rules for the hearing, all attendees are requested to please switch all cell phones into silent or completely switch them off, and to kindly mute themselves when not presenting, and to please switch off videos at all times unless requested to switch it on. In terms of the hearing for today, we have received 2 requests to present in this hearing. And in terms of us having to start, we will start with Mr. Steve Dadim from RSA Cluster Group and NPC. I'm not sure if he is available. If he is, I am going to be requesting him to switch in his camera so that I can swear him in. Mr. Dadim, thank you and good morning to you, sir.
Morning, Ma'am Chairperson. Thank you. It's nice to see you again.
Good to see you again this morning. And I think you do know our procedure. We are going to be requesting that you be sworn in before we can start. We can give you an opportunity to start with your presentation. May you kindly raise your right hand and affirm the following. That do you solemnly declare that the evidence you are going to give to this panel is the truth and the whole truth?
I do.
And may you, for the record, please state your name, organization, and designation.
My name is Stephen Michael Jardine, and I'm Managing Director of the RSA Clusters Group, which is a non-profit company.
Okay, all right. On that note, thank you very much.
Can I suggest we swear in also Mr. Botha, because he's going to also participate in part of the demonstration or the presentation of mine this morning.
Oh, okay. It's a joint presentation between
Correct.
you and I'm not sure, Mr. Botha, since I've noted that he is an attorney, unless if I'm incorrect in terms of the program that we have, and normally we request attorneys to really confine their presentation to legal submissions only, other than to be sworn in. But he can come in and state what he wants us to do with him. And please let him come on the camera, or let him switch in his camera if he's not with you. Mr. Botha?
Good morning, madam. Can you hear me?
I can hear you, but I can't see you. May you kindly switch on? Oh, yes, I can see you now. Thank you. Good morning, sir.
Good morning. I have, madam, I have a presentation which both me and Mr. Jardine will jointly present. The presentation involves a matter which I've shared with NERSA on Friday, and the expectation was on Friday that I will again present this to the panel today, given its fundamental importance, with Mr. Jardine.
Okay. Normally, in terms of the outlined process, we do take presenters, we request presenters to take an oath. Do you have an objection? Because normally legal representatives are expected to present legal issues to the hearing, as opposed to having them sworn in the normal way as other presenters.
No objection, madam.
Okay, in that case, then may you kindly raise your right hand and affirm the following. Do you solemnly declare that the evidence you are going to give to this panel is the truth and the whole truth?
I do.
And for the record, may you kindly state your name, organization, and designation?
My name is MC Botha. I'm an attorney with TRM Law, and I represent the CFMC and some of its members.
Okay, thank you very much. And on that note, then, we can start with the presentation. Please do indicate to us as to who's going to start first. And once you change presenters, indicate that you will stop here and presenter to proceed. Over to you, gentlemen. You may start with the presentation.
Madam Chair, I'll start with the presentation and I'll introduce at the right point so that we can do the handover. MC, if you wouldn't mind just flighting the presentation, please. Thank you.
I'm doing so.
Thank you very much. As mentioned earlier, the casting, forging, machining cluster is it's an industry forum, and as a result of it, I think this is a very important platform to us to actually engage and to talk about electricity tariffs, and not only how they impact on the specific technicalities, but also how they impact on the whole value chain. So during the course of this discussion, I think we'll try and to be briefed, so we'll stick within our time. We are challenged by the fact is that we do not believe that this application that has been put before you by the municipality can actually be a lawful tariff. And so that's going to form a big portion of what we're going to be talking about. And what we picked up in the prior discussion that we had some weeks ago was that there was a terrific error in the cost of supply study. And because of that, there were all kinds of other complications that accrued. And we believe that whilst that error was corrected, we believe that the Ekurhuleni has missed a number of other issues which equally have caused and compromised some of their presentation that they've put through to you. We're also going to address how this whole process is compromising industry and our members, and the impact that it's having on everybody in and around us. And I think if we just look at the fourth point, of course, the tariff application and its information, we'll go through it in quite a lot of detail, and then we'll look at whether or not the quality of the tariff application, in our view, is what we would expect, and we will then conclude with details of the issues at hand. So if we can just go up a slide, please. So the cast, forge, and machining cluster that we've talked about in some of the papers and so forth that we've had between us is a subsidiary of the cast forging, I beg your pardon, of the RSA clusters group, and as such, there is direct linkage between the two clusters. Essentially, we are an industry body, and basically our whole aim is to develop, revitalize, and grow manufacturing in South Africa and into the SADC region. And at this point in time, one of our biggest challenges is simply electricity and electricity prices. Next slide, please. Our members are a very special group of manufacturers, and the sorry, I beg your pardon. So we're a private initiative. Our agenda is manufacturing orientated, and then our goals are focused on revitalization, is what I was saying to you earlier. We are a member-based organization, so we don't have ownership, but we have a membership, and predominantly the membership comes from the steel and metal processing sub-industries, which are now basically in distress for a whole number of different reasons, but not excluding the fact is that the pricing of electricity is a huge deterrent to manufacturing in the country at large. Our membership includes a mix of large and small companies, making up a good part of manufacturing across the Ekurhuleni base. Next slide, please. We believe that there are a number of compromises that have taken place in this environment, and the challenge that we see here is that we aren't seeing competitive tariffs. We're not seeing low-cost tariffs. We're not seeing the ability to actually use electricity to compete with other areas in the country which have much better tariffs than what Ekurhuleni is actually offering to the manufacturing industry. To that point, there was a comment made in the previous presentation some weeks ago, and in that presentation, I made a similar comment, and following that presentation, I did submit additional information to yourselves at NERSA, which hopefully has formed part of your information pack. What we are also seeing is that in this environment of compromise, is that we've taken actions which have not only compromised the price-setting process itself, but also the industry and other users of electricity in and around the Ekurhuleni base. What that has done is we've seen almost a game of fast and loose, and I think it's fair enough to say is that we've taken our manufacturing economy and done things to it that have not really made much sense in terms of how we should go forward with the process of growing and developing the Ekurhuleni economy as a whole. And the problem is with an Ekurhuleni failure, as they themselves will tell you, you start seeing failure across the country. This is not a situation where we are playing with a small, unimportant municipality. This is a very, very important municipality for so many different reasons. But what they've done is because of robbing manufacturing, basically taking money away from manufacturing and giving it to the domestic, what we've done is we've taken the jobs and we've rather just feeding people. That's crazy. It really doesn't make any sense to us. And this compromise itself is something that we've been very, very concerned about. And we are equally concerned about the fact is that when we're doing the cost of supply study and starting to actually look and see what it's telling us, is that we fully understand what's in that cost of supply study to the point that we don't make errors, to the point that we are not compromising our users, whether it be manufacturers, whether it be other industry, or whether it even be our homesteads and so forth. The other problem, of course, is that...
Mr. Jardine, before you proceed to the next problem that you want to share with us, I think we are missing the presentation. And I was going to ask Mr. Botha as well to switch off his camera. The presentation, it's not projected. I don't know, maybe it's on my side, or is it me? I don't know, colleagues. I think it was on my side. Apologies, I've picked it up. Yes, you may proceed with your next point that you were trying to highlight. And thanks, Mr. Botha, for switching off your camera. I think it will assist with the bandwidth. You may proceed, Mr. Jardine. Apologies for the interjection.
Okay, so I think, these compromises are obviously very, very difficult in every way. And what we're sitting with is we're going to have to do redistribution and everything has to be balanced again. And everybody is actually going to lose in this process. So it's put everybody at risk. And if we can just go to the next slide, please. So what we're sitting with now is a situation where we essentially have a dysfunctional environment where things are not working the way that they should have been working for a long time. And as we go through in this basis with high tariffs versus other municipalities in South Africa, we have these challenges where we're going to consistently be putting everybody under pressure which shouldn't be there. And these compromises that have been made by the municipalities, arguably unlawfully, has basically caused a huge rift that has to be rebuilt or at least closed. And the compromise, as I mentioned earlier, to manufacturing has simply been we've lost jobs, we've closed factories, and we've given that electricity to others. And part of that challenge is when you start doing your sums, it doesn't add up to what it used to when you take your manufacturing weight out of your electricity mix. So where we sit with now is this compromise, and if we can just have the next slide, please. And the situation, which should never have happened, but we've got unlawful tariffs that have been declared in the courts earlier this year. We've got a situation where we are here following an application which was not resolved during the first application, and a situation where we've got documentation which has contained errors of material nature which had to be redone. And we've got a situation where the municipality, EKURHULENI, has basically assumed that they can actually take a particular part of the cost of supply study and apply it in such a way that it might be whole to the whole outcome. But of course it wasn't, and that caused a whole lot of problems. So in the reapplication, what we found is that once again there's an incomplete set of documentation, and we've basically received the Excel spreadsheet or the cost of supply study, and then which we assumed basically would have been analyzed by yourselves at NERSA and evaluated before release. I think we're starting to learn is that these are going to be powerful tools in the way that we use them if we get this particular mix right going forward. And there's some Word documents basically alleging that they are summarizing the cost of supply study contents, and then a list of different documents that were applied for regarding the tariff that was applied for. Next slide, please. There was also a lot of missing information which was not provided. And in this particular instance, after a discussion prior where we called on the municipality to actually declare certain information, certainly around assets and other major portions of their costs in the cost of supply study, and certainly missing documentation includes the verified NERSA version of the cost of supply study, a ring-fenced account contribution to consider regarding the electricity distribution, and then of course any accounts that might have been taken into account in the piecing together of the cost of supply study document also were missing in the package. And improvement plans, of course, the D forms, of course, would have also made it quite a bit more informative. And then lastly, tariff application certainly could be improved if we had the improvement plans to restore the compliance of what EKURHULENI was going to be doing in terms of their distribution function. And then lastly, the tariff application, in our view, because of these missing documents and because of some of the other factors that you'll find in the details itself, it's basically unlawful, is going to be it has been unchanged, and as accordingly, it was unlawful in the sight of the courts in the beginning of the year. We believe it's going to be suffering the same problems this year. Next slide, please. I'm going to ask Mr. Botha to speak to some of the specific issues that we found in the documentation and that was made available to us. And so out of the cost of supply study, of course, we've done a deep dive, and I think that this is it's quite telling, and up to you, MC.
Thank you, Steve. If I can maybe just skip back to the previous screen. And thank you for the opportunity to do the presentation and to make some contribution. You will note from the EKURHULENI application, just to go through the missing documents which are telling and which manifests later in this presentation, is there's no verified cost of supply study. There was an absence of ring-fenced accounts. The D forms were missing. So for starters, there were crucially and fundamental information which just appears nowhere. This, of course, is the reapplication for EKURHULENI's 24-25 tariffs, which follows upon NERSA essentially sending EKURHULENI back to go and do its homework and to improve its tariff application, as well as the way in which it supports the tariff application. With the submissions we're about to make, the ultimate, we will illustrate to NERSA why this application is similarly flawed, and that EKURHULENI should similarly be sent back to go and do its homework, do a proper application, properly motivated and substantiated, and then do a further reapplication. Fortunately, the immediate question would then be, well, what then? Because there would be no lawful tariff, theoretically. Fortunately, the court order which directs this reapplication has dealt with it, and there is a default position where a prior tariff will remain the default tariff until such time as EKURHULENI has done its job, has properly made a motivated application, which enables NERSA to discharge its role. The benefit of that court order is that it does not place NERSA under unnecessary pressure, where it feels that it's obliged to determine a tariff, quote, warts and for all, unquote. So we will now proceed to illustrate that at basically two levels. This tariff application has a error which is almost as big as the 7-odd billion rand error which was previously discovered in this application. And our fundamental concern is that the errors which we are going to illustrate to you today could not have been because of a lack of application. It seems that these errors are intentional and that they are engineered to produce a certain tariff outcome. So we would ask NERSA to focus very carefully on the information that was submitted to NERSA by EKURHULENI. Finally, before I move into the slides, these slides are an overview of detailed tariff submissions which we have already submitted. We are prepared to submit more information if requested to do so. But from what we will also forward to NERSA a copy of these slides, which we are hoping will provide enough information for NERSA to be able to exercise its discretion. So moving into the slide, we are firstly dealing with the BAU revenue, which is the business as usual revenue, and that is being calculated in the new tariff application with the associated cost of supply study based on the wrong tariff inputs. So I'll take you through it. BAU is the revenue generated for year 2 based on the tariffs for year 1. So this is Cost of Supply Framework 101. The overall BAU revenue gets compared with the overall revenue requirement. This then established the average increase required to meet a cost-reflective tariff. So in the cost of supply study, the percentage increase needed has been calculated as 19.1%. Below, we show that the BAU revenue is based on manipulated tariff inputs. So if you look at the total revenue requirement, this table was extracted from the cost of supply study, and the tab appears there. It's in the summary charts here too. You will see the total revenue requirement was calculated at 24.7 billion rand. And the BAU revenues, which makes that up, is 19.8 billion rand from the tariffs from year 1, plus the free basic electricity, and the revenue divided by the cost then comes to 83.9%, which requires an increase from the BAU revenue to achieve the revenue requirement in year 2. In the cost of supply, BAU revenue and the revenue requirement then gets split up per customer category, and the increase needed is then determined per customer category. So that is just the base on how that was dealt with. So in the cost of supply study, City of Ekurhuleni does not use the actual load profiles for the various customer categories. Now, notably, these actual load profiles exist and they were part of the Lexpert cost of supply study, but they're not used. The COU surprisingly uses manually allocated load profiles. In other words, what they do is they ignore the reality which they had available, and they just arbitrarily allocate load profiles to engineer a specific outcome. For time of use customers, which represent the bulk of the kilowatt sales, City of Ekurhuleni assumes that 100% of sales take place during off-peak times, bearing in mind that for industry, most of them run 7 days a week, 24 hours a day. The result of this is that Ekurhuleni underestimates the revenue from industry. The effect of this, if you follow the methodology of the cost of supply framework methodology, is that it inflates the required percentage increase needed for the industrial and other concerned time of use consumers. In the next 2 slides, we will illustrate the error reflected in the cost of supply study. And in the following page, we will illustrate the manipulated impact on revenue, and we will quantify by how much the industrial percentage increase needed has been artificially exaggerated. So if you look in Ekurhuleni tariffs E right through to tariff I, the second column there, I don't know whether you can see my cursor, but it's the 1 TOU marking data available. It's true. That means these are all TOU tariffs. There are 6 tariff categories for high seasons and low season, and each of them comprising off-peak, standard, and peak. And these tariff allocations, this is where the tariff allocation happens, should total 100%, being the sum of the available time periods. Now, what immediately becomes apparent is in high season, we only, according to the COU cost of supply study, only 25% of electricity is used, energy is used during the off-peak period, with no usage during standard and peak. And during the low season, 75% of energy is used during the off-peak period, with 0% during standard and peak for all the TOU tariff categories. There's a reference from where this is copied out of the cost of supply study. And it's clear from that table that all time of use sales are incorrectly, arbitrarily allocated to off-peak usage. Again, we repeat that the actual load profiles are missing in the cost of supply study despite these profiles being available. In our written submission, the revised value of the BAU revenue from time of use consumers are calculated, taking into account realistic load profiles. A realistic estimate that the BAU revenue for the energy portion will increase by at least 30% if the correct numbers are used. And in that table below, you will see that the required revenue, the revenue requirement, and the BAU revenue changes, and that the required increase to achieve the adjusted outcome from using this cost of supply tool would result in a 13.8% decrease in tariffs for that particular tariff line, which is the medium voltage less than 230 at 400 volt, and or greater than 230 at 400 volt and less than 11 kV and 1 MVA. That's the tariff D tariff category. Obviously, the outcomes would differ per tariff category, but that would require a decrease in 13.8% in the tariffs. At the same time, and again, we believe that this was intentional, the BAU revenue for maximum demand users is calculated with a grossly exaggerated loading. In the cost of supply study, again, COU does not use the actual load profile for the customer categories, despite it being available. Maximum demand consumers represent a large portion of the COE kilowatt hour sales. And then COE misleadingly allocates fictitious load profiles, makes an input mistake, and calculates the revenue by almost double of the available time, which results to, it's the mirror image, a reverse image of what was done to time of use consumers, which results in an overestimation of revenue from the maximum demand consumers, which underestimates the percentage increase requires from the maximum demand consumers. As I did previously, the next two slides firstly illustrates the error, and then the following slides illustrates the manipulated impact and quantifies by how much the increase needed has been underestimated. So this comes out of the same table in the cost of supply study presented to NERSA, upon which NERSA, we believe, will rely to do a tariff determination. And you will see, firstly, these are all maximum demand users, but they are not time of use. It's generally tariff A1 through to tariff B and tariff A. You will see the exact opposite to time of use. There's no off-peak allocation, but there is, in the high season, 52% allocated to standard and peak, and in the low season, there's 127% allocated to standard and peak. If you add it up, it comes to 179%, whilst obviously it can only total 100%. What this table in the cost of supply study indicates is that maximum demand sales have been allocated a fictitious 179% of time. This is not just an unfortunate error. I mean, it was done in order to accommodate or to mirror the change in time of use sale statistics. So for maximum demand users, the correct kilowatt hour revenue may be calculated based on the sales forecast. Customers are being charged the same kilowatt hour rate over all time of use periods. We've calculated the value of the BAU revenue from maximum demand consumers. If the correct figures are used, the BAU revenue for the energy portion of the revenue requirement will reduce by 44% in the written submissions. That is Table L. We've done this calculation with reference to Tariff B for domestic, and an increase in the BAU revenue of this proportion leads to a completely different cost of supply study outcome. The Tariff B domestic tariffs will need to increase by 52%. And the application by EKURHULENI was for a tariff reduction of 12.7%, which makes the application and the cost of supply study entirely irrational. And we submit that NERSA can simply not rely on it. We've made a footnote that using the same cost of supply study for the 2026-27 tariff decision, NERSA awarded a 19.71% reduction in the Tariff B domestic tariffs using the same erroneous cost of supply study. Next, there's a second leg to this. The two previous issues both combine to show the one engineered impact. But there's a second fundamental error which is made by City of Ekurhuleni in its cost of supply study. In the cost of supply framework, Table 1, losses must be calculated at 12% of sales. In the table which appears on the screen in front of you, we illustrate that this was not done. Instead of calculating losses at 12% of sales, the cost of supply study calculates losses at 12% of purchases. But the purchases are already, the losses are already included in the purchases. You have to, based on the cost of supply framework, look at what your sales figure is and then add 12% to it. The effect of this calculation is an error of 185 million, rounded, call it 186 million rand. So as a result, and our conclusion is that the tariff application cannot form the base for a lawful tariff determination. It is fundamentally flawed. It is based on manipulated, vastly incorrect tariff assumptions and figures, and NERSA must reject the application as the base for a lawful tariff determination for 24-25. City of Ekurhuleni must go back, do its homework, submit a compliant tariff application with a cost of supply study, and that will enable NERSA to make an appropriate tariff determination. In the meantime, we submit NERSA is under no pressure to take a decision now. The default position would simply kick in, and we would be able to eventually determine a lawful tariff for Ekurhuleni. Thank you, Madam. That's my submission. Those are my submissions.
Thank you very much, Mr. Jardine and Mr. Botha. On that note, I'm going to allow the panel members to raise questions, issues of clarity that they may have based on your presentation. Members, any questions, issues of clarity that you may have on the presentation made by Mr. Jardine and Mr. Botha? If you have any, please do raise your hand and you'll be recognized to make your input. And thank you. I see Mr. Mkize's hand is up, and Ms. Maseti, I'll start with Mr. Mkize. Over to you, sir.
Thank you, Chairperson, and thanks, Mr. Jardine and Botha, for the presentation. From my side, I'd just like to know, what you're saying, since 2009, you've litigated with NERSA to protect the electricity interest. And you are highlighting this issue regarding the business as usual figures vis-a-vis what they, as a municipality, have included in the cost of supply. I would then like to know, in terms of the consultations with the municipality engagements, have we had any in terms of comparing these figures? Because you are now dealing with these figures, and I hope you have provided exactly that to the team. And when you're sitting at in this platform to then look at these figures, it needs one to, it's a bit rather difficult because it needs one to sit down and do a proper comparison of what you are coming up with. Hence my question around consultations and engagements prior to lodgement, if there were any, or if there is any concern around that, because the history of litigation is not something any entity can necessarily be proud of. Thank you.
Thank you, Mr. Mkize.
Let me answer that question. So,
okay, proceed, Mr. Jardine. I wanted to take the other panel member, but you may.
Sorry.
Let me take Ms. Maseti first, because she may raise questions that is either linked to what Mr. Mkize said or not at all. So it makes it easy to allow the panel to raise questions and then hand over to the presenters. Ms. Maseti, may you come in, please, ma'am? Just note the questions raised, Mr. Jardine, and that will be helpful. Over to you, ma'am.
Thank you, Chairperson, and thanks to Mr. Jardine and Mr. Mertens. For us to really engage meaningfully to the errors that you have pointed out and to independently verify these increases and decreases that ought to have been taken into consideration, I guess it is something that we need to go granular in each of these specific issues, because you are pointing out structural misalignments in the model that has been used by the city of Ekurhuleni. So I just wanted to firstly then find out in respect of the revenue that is required, the revenue of 24.7 billion. How does the calculation compromises this revenue that is required just to enable NERSA to then navigate its independent verification and be in a position to find or to get to the revenue that is believed to be the genuine revenue that the municipality requires, apart from some mathematical errors that you pointed out, whether they are intentional or not intentional, or whether they are just sort of obvious errors and errors that are made in good faith or otherwise. But I think for us, it is important that we fully appreciate the errors, looking at the figures and be in a position to see how those errors will impact on the revenue of 24.7 billion that is required. And then also, I think that will also be linked to the question of unfair cross-subsidization, as you pointed out, the inappropriate allocation of the load profiles. As we all know, that is something that is required in terms of step 4 and step 5 of the cost of supply framework. So I'm wondering if you have looked at the impact of that sort of misallocation. Is it between the maximum demand customers that you have indicated and the other and the time of use customers that you have spoken about, or is it also further than that when you look at also the domestic customers? I just want to also understand to what extent are domestic customers overcharged, or the likelihood of domestic customers being overcharged as a result of that issue of the the issue of the load profiles. Then how do we then verify your claims that there are inflated cost assumptions that have been made here? How do we, from our side, we hear what you are putting forward to us, and it is the first time that we really get into this aspect. If you could recall the public hearing that we had, where you presented, I think it was on the 28 April of this year. Now, the issue of these inflated cost assumptions and also, these specific increases that are quite excessive, those things who have not been presented at that stage. So I would just like to understand, how do we verify the inflated cost assumptions that are made? With regards to the reference to Eskom, assuming that these are peak loads and then the municipality looking at the off-peak and the peak, what kind of adjustments from the regulator's point of view can we make here? What if also Eskom has made some miscalculation from its side. So we do need some information that will enable us to also verify if all of these are supposed to be peak, and whether they are also off peak, so that the cost associated with those can be properly allocated to peak as well as off peak. How do we go about looking into this, especially with regards to the calculation of the bulk purchase costs from Eskom? So we just want to see, to be able to do our verification there, and then get to the right costs that are supposed to be recognized in the revenue requirement, insofar as the bulk purchases made by the city of EKURHULENI from Eskom. We do note the point that you are making, that because of the miscalculations and all of that, obviously it will distort the required revenue baseline, and as a result, this will cause a higher tariff than economically justified. And then I just want to get to the 179. I couldn't, because obviously from your side, you're dealing with something that you have already calculated, and it becomes difficult for us to quickly verify and do the calculations, as we're also listening to your reasoning as to how you get to the business as usual revenue distortion on maximum demand users. So if you can please touch on that again. I assume that you are referring to the large industrial and commercial users when you refer to the maximum demand users vis-a-vis the time of use users. So this over recovery of 179%, can you just again just show to us how is that a cost, sorry, an over recovery, so that we can be in a position to see if indeed this is an inefficient cost, that we need to look carefully at it, and whether it is something that will subsidize other tariff categories. Yeah, so that's what I wanted to check. And then if we can now go to what we are requesting NERSA to do with all of this, so that we rectify this. And obviously this is going to require us to thoroughly look at the information that is before us and engage on the cost assumptions that are put before us. Now, there is a deadline of 30th of June 2026. Then would it not impose legal risk on NERSA if NERSA is unable to make a determination by the 30th of June to comply with the court order that NERSA must be in a position to take a decision on these redetermination applications? What is your take on that, given what you are proposing to NERSA to say, well, NERSA, because of all of these problems, you are not in a position to complete this process. The city of EKURHULENI must go back to the drawing board and correct the cost of supply study, so that it can base its tariff application on a correct cost of supply study. Then that's what you will then look at. So the question is then how that is going to affect NERSA insofar as the court order is concerned, for NERSA to comply with what the court has indicated regarding the 30th of June deadline. And then the other thing that I would like to check is in relation to the deforms. with the deforms, the fact that you are saying they are missing, I'm not sure for which years, because also from our side as the members, we don't really get to see the deforms themselves, but will be the staff that gets into detail and check what information has been captured into the deforms. I just want to check from your side, with the deforms that are missing, how that prevents yourselves in terms of ensuring, or at least verifying the cost data that is contained in the cost of supply study, as you have already indicated to us. What are some of the deficiencies that you have identified? How significant is the missing of the deforms affecting you or constraining you from making a meaningful input insofar as cost data is concerned, of which cost data you've already engaged with insofar as the cost of supply study is concerned? The last question that I have relates to the non-technical losses of 12%, the manner in which the 12% has been factored in, which you say that it is based on the purchases as opposed to the sales, or the sales figure. The question that I have: how should we treat, or are you in agreement that the 12% can be considered by NERSA? I'm asking this question because previously, for this specific municipality, in the hearing of 28 April 2026, it was argued by other applicants, and I think, I'm not sure if you have also said the same thing, but I think there were two that indicated that the costs associated with non-technical losses should not be granted, because those costs must be considered as inefficient in relation to Section 15 of the Electricity Regulation Act. Hence, I would like to find out your stance, whether from your side you do agree that we can consider the 12% for as long as it is appropriately apportioned to the sales figure as opposed to the purchases. Thank you, Chairperson. That will be all the questions that I have.
Thank you very much, Mr. Mkhize and Ms. Maseki. I think I am partially covered from my side. However, I just wanted to raise a point of clarity in relation to the issue of the actual load profiles for various customers. I think in the presentation, there was a slide that talked to actual load profiles for various customers, which was said the applicant did not use, but instead the applicant manually allocated load profiles of customers. And my question is to the presenters, did they highlight this with the applicant? And how have they verified this? And as well as if it would have been helpful to really get a list or an indication of those customers, because if you say various customers had their load profile done manually instead of taking their actual load profiles, it would have been helpful for us to just get that list and see, because if you say various, I take this to mean not all customers. It may be one, it may be two, it may be three, but it's not all. So if we could just be given information relating to those various customers, which are those, and the impact, so that as we consider this particular application, we are clear on what this means. That is just that one question of clarity from my side. I'll hand over to the presenters. Mr. Jardine and Mr. Booth, you may come in. You can just agree who's going to start first. Thank you.
Thank you, Madam Chair. If Mr. Jardine could just take us through the consultative process and the submissions made, just the steps taken, I will address the technical aspects of the presentation.
Okay, thank you. Over to you, Mr. Jardine.
Thank you, Madam Chair. I think this is a very important process for both industry and for the municipality. What we have tried to do is to actually engage with the municipality around various issues on the cost of supply study, and because of the factors that it's detailed, and because of the factors that there's a lot of activity to actually cover and so forth, we looked at it from a comprehensive approach, because we believe that it's important that not only a handful of people in the industry understand, but that a lot of people get to understand how these things actually work, which will actually in the long run benefit everybody. And having discussions with the municipality, probably more from an economic point of view rather than from a financial point of view, we basically are, in fact, I've scheduled a meeting for next week, but we haven't managed to actually have, during the course of this narrow period, to actually go back and engage with them directly on all of these different issues. So I think that is definitely a weakness in where we're at. Everybody's busy, and I think that this is not necessarily seen as the most important thing that we have to do from their side maybe, and from our side maybe. But those are things that we've got to look at and trying to strengthen in the process going forward. Part of the challenge I think that we have is that in this whole process of price setting, in our prior discussion, it was quite clear that the municipality has got the information and has got a lot of ability perhaps to share with designated groups maybe. But they were quite clear also is that they didn't want neither NERSA nor ourselves to actually see certain of their information. And I think that needs to be covered, because what does happen is that there are definitely elements of the discussion that need to be openly discussed between parties who are quite happy because of the fact is information has been shared privately in such a way that we've all maybe signed non-disclosure agreements to make sure that information doesn't get out into the marketplace. It would be foolhardy of us to actually think that could just be provided openly, but at the same time, I think it's foolhardy of the municipality to assume that that's a brick wall that we never will climb. And I think that needs to be broken down, not necessarily in a discussion between a municipality and its consumers, but rather in a strategic forum where the regulator, ourselves, and others agree to how we're actually going to manage this process going forward, where we can actually talk to each other about the key issues and disclose information to each other, which will be meaningful to each one. So that's the first answer I think that is needed. I do have a meeting that was supposed to happen today at this time, which I had to postpone, and that was really to kick this whole process off, taking into account some of these key issues that need to be discussed. So I think in short, no, we haven't really spoken to the municipality in a meaningful way around this particular issue that we're talking about here. And I think there's perhaps another issue that we need to maybe also take into account, and that is that in this process, we are assuming it's not only industry doing some calculations and the municipality doing calculations, and then we've got to actually have a look at it. We're actually assuming in the broader scope that yourselves would be doing evaluations of what these cost of supply studies are actually telling us, and that with your resources to actually come up with some of these answers also. So I think all three parties are very, very important to this process, and in the next steps as we move forward is that we make sure that that process is defined and that we know how that works, so that we know who's relying on which information, when and where, and how we actually make sure that everybody's got the right kind of information at their fingertips. So from a consultative point of view, I think that's sort of where we're at the starting stages. I think we need to get some steam up on that. With regard to some of the questions that have been asked, I think many of them go directly to the technical information that Mr. Botha presented. I'm quite sure that the issues are being very technical. In some instances would be very difficult. And my comment that I would like to make quite simply before I hand over to Mr. Botha is that when we look at these documents, NERSA has actually laid out the process pretty well in terms of the technical activity and so forth. And we don't believe that there are necessarily mistakes made in such a way that the whole process is flawed. We believe the process is not flawed. What we do believe is that it is quite a difficult, and it's robust, but at the same time, it's not all that user friendly. And so some of these difficulties are certainly causing some challenges as ourselves and others try to actually work through these documents and so forth. So I think that that's something that we do have to also recognize, and with that, what we need to do is we need to ensure that, especially in the municipality and maybe at NERSA, is that we are well skilled how these things actually work. So once one runs through these processes, that when there's errors made, that they are easily picked up and there's proper double checking to make sure that everything actually flows and works together and so forth. Because I don't think, we suspect that there are certain linkages that people are not understanding, and as a result of that, it's causing problems. Over to you, MC.
Thank you, Madam Chair. Just to link up to what Mr. Jardine said, and I think the thrust of your question was perhaps more pointed. And your question was whether there had been discussions between the presenters and the municipality relative to the tariff reapplication. And indeed, Madam Chair, a detailed written submission was made by the presenters to both NERSA and EKURHULENI Municipality, if memory serves me correctly, on the 3rd of June, dealing with the detail of this tariff application. I will ask Mr. Jardine to forward to NERSA a copy of the submissions that were made for your record. And I have it available, which I can also email to you if needs be. So that's insofar as the consultation was done, bearing in mind that the tariff reapplication is not part of the standard consultative process. The tariff reapplication is for the 24-25 tariff was a unusual parallel process directed by court. So the normal budget consultative process with the municipality, where they prepare their budget, they consult the public, they would consult on the perhaps the cost of supply study, etc., etc. That wasn't followed in this instance. When the tariff application was submitted to NERSA the first time, the presenters had sight of the application. The supporting documents was when they were invited to participate by NERSA. We immediately communicated the submissions to both NERSA and EKURHULENI, just to answer that question. Then moving along, I will deal with firstly the chair's question, which was posed last, regarding the load profiles, whether it was highlighted with the applicants. Madam Chair, it was highlighted with the applicant. It was highlighted with the applicant at the very least on the 3rd of June when we made our tariff submissions. But Madam Chair, you will also appreciate that given the extent of the error in the tariff application on the first round, once that error was discovered, it was enough to stop the entire process in its tracks. And the public, the presenter, CFMC, did not go beyond that error in any great detail because it was just completely irrational, justifying it to be sent back. What I think the public is entitled to expect is that a tariff application isn't so fundamentally flawed in so many different aspects as to expect the public to go and examine each and every aspect over and over again to make sure that it's correct. That job, that is the function, it's the role of, firstly, the municipality, and secondly, it is the role of the regulator to test that cost of supply study. I think what has gone wrong here is that there was no proper consultation between the municipality, EKURHULENI, and the public regarding all the aspects of the cost of supply study, and that is coming out now. Madam Chair, you will notice from our submissions, the detailed submissions, that, well, it's common knowledge now that the first error was some 7.2 billion rand. The errors that we highlight today, it amounts to an additional 6 odd billion rand in a single tariff application, which suggests, Madam Chair, that it's not just a mistake, it's a complete non-compliance with the principles of the cost of supply framework. The applicant, the presenters does not take issue with the cost of supply framework. The presenters take issue with how the cost of supply framework principles are being applied by EKURHULENI in the cost of supply study. In addition, Madam Chair, the numbers which are being used to criticize the cost of supply study are not the applicant's numbers. These numbers are the numbers presented by EKURHULENI in its cost of supply tool. The presenters aren't picking random numbers and arguing with random numbers. We are simply using what is being presented. So to move on to Ms. Maseti's question, is the structured misalignments in revenue for 24.7 billion rand, and how does it compromise NERSA's ability to determine an appropriate tariff? And maybe, Madam Chair, it would assist if I just highlight briefly for all of us to look at the same thing, how this works. When a tariff determination is done, you have, using the business as usual information, you have a year naught, a year one, and a year two, and the tariff determination is for year two. So in respect of 24-25, the current tariff application, the 24-25 tariff year would constitute year two. So what would happen is that you take the year naught consumption figures, energy usage loads, you would take that and you would multiply that with the year one approved tariffs for the applicant. That would give you the BAU revenues. And you would then determine the BAU revenues for year one with the year two revenue requirement determined in terms of the cost of supplies study. And the difference between the year one BAU revenue and the year two revenue requirement would then tell you what the required percentage increase ought to be. That revenue requirement, or that difference, is then applied to the different tariff categories using the BAU requirement with the new tariff year. Of course, the revenue requirement for year two is based at that time on the Eskom tariffs, which already has been approved at that time, because that's how the tariff determination process works. What's happened here, and I'll take you to it now, is that the year naught usage has been completely ignored. And if you will allow me to just put it onto the screen. Are the slides available for everybody to see, if I may just ask?
Yes, we can see it, Mr. Botha.
Thank you. So this
You can
again
just
comes
put
out.
it in a presentation mode if you can. Thanks.
I can, certainly, madam. So again, these tables which I'm presenting here aren't tables created by the presenters. These tables come out of the EKURHULENI cost of supply study. And the table you see on the screen applies to all the time of use tariffs. For purposes of our internal study, we have used the Tariff D study, the one at line 19. But the extract relates to all the time of use studies. And you will see that for all time of use studies, there are no standard or peak consumption. There's only off-peak consumption. And to address a misunderstanding which appears from Ms. Maseti's question, I suspect, about if Eskom were to make incorrect assumptions. These assumptions do not come from Eskom's figures at all. The only importance of the Eskom figures is what the Eskom tariff to municipalities would be for year two, because that impacts the revenue requirement. The numbers we show here impact the BAU revenues. bearing in mind BAU revenues rely on A, the consumption, the load for year naught multiplied by the tariff for that tariff line in year one. That gives you the BAU revenue. So it has absolutely nothing to do with Eskom potentially making an incorrect assumption regarding peak and off-peak usage for the different TOU tariff categories in Ekhululeni. These assumptions, the off-peak assumptions with the zero standard and peak assumptions, were made by the municipality. The actual figures are available in the L-Expert cost of supply study, but was simply just not used. So that's a pure, just a pure error. And the information, if it's not presented to NERSA, can be obtained by NERSA when it considers the cost of supply study, saying to the municipality, but you have not provided us with verifiable information. Send us your actual consumption usage. This is a glaring error. It's just a overwhelming mistake. If I go further, I'll just go to, this is the MD uses. And you will see that firstly, maximum demand, which are mostly the residential domestic users, you will see it totals 179%. So at its most basic level, it tells you that we are, Ekhuleni, not we, Ekhuleni is making an assumption. Ekhuleni is telling NERSA that domestic users for 24-25 will be using almost double the energy used in the previous year. But there's absolutely no reason for firstly making that assumption, and secondly, there's no substantiation for that. It is simply a number that's arbitrarily entered into the relevant time slots. And if you understand how the model works, if your BAU revenues are overstated when you compare it to your revenue requirement, what it does is it suggests that you need a lesser increase in year two. If your BAU revenue is understated for year one, the gap between year one and year two would be bigger, which then requires a larger increase for that particular tariff category or tariff categories. And this is exactly what has been done here. The maximum demand BAU revenue was overstated by almost double. The TOU BAU revenue was understated by something like 30%. The compounding effect of the two would be that the domestic tariffs will have to increase, if it's corrected, will have to increase by 52%, and a revenue for the tariffs for TAU consumers will have to decrease by almost 14%. That's the
Mr.
effect
Porter,
of it.
sorry to interject. In the interest of time, without really repeating the presentation, if you can just be straight to the question raised by members, because I think I've allowed your presentation to go beyond 20 minutes and also even the responses. So if we can try and wrap up with regard to all questions raised by members, that will be appreciated. Thank you, sir.
Thank you, Madam. I will certainly speed it up. The one question was, how do they verify claims given the 28, the April submissions? I've explained that it wasn't raised at that stage, given the 7.2 billion rand error. I've dealt with the incorrect assumptions made by Eskom. They made no assumptions. These are all assumptions by EKURHULENI. I've explained how the 179% over recovery would impact. The deforms, how does that prevent verification? And the answer to that is actually quite simple. Number one, NERSA needs the deforms to verify the information in the cost of supply study and in the application. That's a secondary verification process. Also, absent deforms, absent ring-fenced financial statements, absent audited financial statement, it becomes a mission impossible. There was a question regarding non-technical losses and the cost associated with non-technical losses. Madam, if it's any cost associated with non-technical losses, being the losses above 12% above sales, should be disallowed. They cannot be efficient cost at all. The cost of supply study and the tariff determination will have to take that into account. And Madam, then just lastly, for purposes of the, I'm just trying to find, there's the court, there's the judgment, the order for your benefit, which applied to EKURHULENI. Does it? Yeah, it does apply to EKURHULENI. And if NERSA... Sorry, there's somebody's phone is speakers on.
Mic is open, please. Can we just check our mics and mute them and so that we don't disrupt Mr. Booth? And you may proceed, sir.
Thank you. I would direct you to clause 13 in the order, which says if you fail to determine the applicable tariffs. Now, it doesn't allocate any blame by saying that if NERSA could fail to determine the applicable tariffs for several reasons. And then in the absence of leave from this court on good cause shown for an extension of the period, then the tariffs applicable to EKURHULENI shall, and this is the important section, until determination by NERSA of the 24-25 tariffs will then be the following. And then there's a default position. I'm not going to go through the default position, but at the end of June, the default position simply kicks in, and then EKURHULENI and NERSA or EKURHULENI must then do its homework, fix its cost of supply study, fix its tariff application. We must go through another consultative process, and eventually, in a perfect world, we will arrive at an answer. NERSA will make the determination, and then that determination will then supersede the default position. But until then, there's not going to be uncertainty about the tariffs. The default position would determine the tariff. until eventually we determine a lawful tariff. I hope that answers all the questions that were raised, Madam Chair. If I haven't, well, if you would please just point it out to me. Thank you.
Okay, thank you very much, Mr. Jardine and Mr. Botha. Members, is there any questions or question that you have raised that you believe have not been answered? In my list, I think I see a lot of them have been answered, but you may come in to indicate if there's a question you have raised that have not been answered, or it has not been satisfactorily answered and you have a follow-up question to make. I see there's a hand from Mr. Mkize. You may come in, sir.
Thank you, Chairperson. I think, firstly, thanks for the responses. I would appreciate if you may have a situation where Janine and Mr. Botha then provide these calculations for proper processing and verification, because we're dealing here with numbers. And it's important to, first of all, look at the principles applied or involved, and then the actual numbers used in terms of the calculation to get to the final figures. Thank you. If they can do that, maybe in writing within the next 7 days. Thank you.
Thank you, Mr. Mkize, for that. And I think from my side as well, I did indicate that on the issue of the load profiles, we've indicated that various customers, and I take this not to be all the customers, and if the presenters can really give us a list of those customers that they believe that their actual load profiles were not used. However, instead, the municipality manually allocated them, allocated the load profiles manually. So if we can get evidence of that as well for us as the regulator, and that will be appreciated. And as well as, I think it is clear that there has been no engagement between the presenters and the applicant, in that the only thing that I have picked up is that they were just written submissions that were done on the 3rd, and I think Mr. Jardine indicated that they are trying to have or to secure a meeting with the applicant. So we hope that we will be given that feedback as a regulator in terms of that particular engagement. Anything else, members, as a follow-up that you may want the presenters to respond? Anything? If not, I see Ms. Massetti, Mr. Botha, I see your hand is up. Let me take the panel member's hand first, and I'll get back to you. Ma'am, you may come in.
Thank you very much. I'm not going to take long, but clearly here there is a serious verification that needs to take place because of the information asymmetry. And I don't think that it will also be useful to just hear one side and the other party is not there, because the critical information that we need to look into is in possession of the applicant itself. So looking at the offer, or at least not the offer, but the proposal that you've made, I just wanted to check if you will be you will avail yourself, if NERSA were to the NERSA team, obviously not from our side as the members, to get into the verification aspect, not to do it with you, but just to have a meeting between the municipality to test the assertions that you made today, so that NERSA can also hear the municipality's perspective on the information that you have provided. I just want to understand whether you will be available should the regulator take that initiative as part of the process of verification, so that all parties are in one room and information can be verified, and then we understand what other information can be provided to the regulator to enable the regulator to thoroughly engage with the information and be in a position to test some of the issues that you presented to us today. That for me, that's the most important issue that we need to do in dealing with the information asymmetry, which then brings us to the situation that we are at as of today. Thank you.
Thank you very much, Ms. Maseti. Yes, you may come in, Mr. Botha.
My apologies, Madam Chair. I jumped the gun a bit there. Firstly, just to respond to your question, Madam Chair, about us having to indicate where the incorrect assumptions were made. The presenters' submissions are that they were made in respect of all the tariff categories, the maximum demand and the tariff categories. If you were to look at the BAU revenue slide, which is I'm reflecting now on the screen, you will see that for each of those tariff categories, exactly the same assumptions were made. And
Please, can someone mute the mic, please? It's really disturbing. Please just double check your mics, everyone that is in attendance, please. Mr. Botha, apologies for that because I couldn't hear you properly as someone was having the mic.
No problem, madam.
You may
thank
proceed,
you for
sir.
So you will see that in respect of each of those 8 tariff categories, exactly the same assumptions are made. That is statistically impossible. And secondly, also in respect of if I go to the time of use, there are, 9 tariff categories there, and they exactly the same identical assumptions were made for each of those tariff categories. So we are not saying it was only in respect of select consumers and tariff categories. It is in respect of all of those. Then, Madam Chair's, Ms. Maseti's question as to whether we will avail ourselves. Indeed, Madam Chair, we will. We will do that. And we would welcome the opportunity to participate.
Okay, thank you very much. And I think Mr. Yadin, in his response earlier on, indicated that there's a possible meeting in the next week, if I heard him correct. So if from your side you're able to secure that meeting, please alert us. And I think from NESA's side, we'll also make ourselves available, but we'll also make an initiative for a meeting. I think, Ms. Maseti, the point that you have made, it's helpful that there is a need to meet with the applicant and as well as the presenters.
Absolutely.
I think to discuss some of the issues. And I think there was a request as well that any other additional information that has been requested, you do have the 7-day period to share it with the regulator. So if you can do that, that will also be appreciated. And I do not know, members, on that note, whether you have anything else that you want us to cover in terms of this particular hearing that we would like the presenters to consider. Anything from your side? Okay, the members are covered. Mr. Yadin, you wanted to say something, I think, as I was talking. You may come and say, I see your hand as well, MC Botha. I'll allow you after Mr. Yadin.
Yes, Madam Chair, I just wanted to thank you. And yes, we certainly will keep you informed of engagements that we secure with the municipality. And certainly if we can facilitate that all 3 parties come together, that would be perfect. And so we'd be very happy about that.
Okay, thank you very much. And I think from NESA's side, The focal person is Ms. Luhuma Masiki. So if you can also copy her on that and the other relevant members, that will be appreciated. Mr. Botha?
Will do.
Thank you, Madam Chair. Again, also I echo the thanks of Mr. Jardine for giving us the hearing. In a parallel matter not related to EKURHULENI, I've been asked to make submissions on behalf of MADIBENG, and I would just like to get directions from the chair about how and when this will take place, please.
Thank you. I think we have now closed. I had thought that the presentation was only on EKURHULENI because I had there's no indication for a presenter for MADIBENG. But if that's the case, then we'll have to really manage our time efficiently. And I believe we've come to the end of the presentation on EKURHULENI's side, and I believe we can now proceed with MADIBENG. If you are going to be presenting Mr. Botha, please just indicate that so that we can follow the formalities of also swearing in, or are you both going to be presenting as well on MADIBENG? And please, let's clarify that before we follow up the formalities for the record.
It would only be me, Madam Chair, for MADIBENG. I don't think, well, I know Mr. Jardine won't be presenting.
Okay. Are you going to be presenting on both technical issues and legal issues, or it will just be technical so that we can decide on the issue of swearing in?
Madam Chair, there is a whole presentation which will be done for AutoCast, which is technical and non-technical.
Okay.
Insofar as the non-technical is concerned, it's really a generic overview. I will read through it, but of course I am repeating what's in the slides.
Okay,
Similar. Yes.
Okay,
Thank
so
you,
I
Madam
take
Chair.
it you won't have an objection in us swearing you in, because you're not limiting yourself to legal issues, but you're going beyond that.
Yes. No objection,
Okay.
Madam Chair.
On that note, members, we have dealt with the redetermination for EKURHULENI for the 2024-25, and we are going now to be proceeding to hear presentation on the MADIBENG redetermination of their electricity tariff application for the financial year 2024-25 financial year. On that note, we have one presenter, and the presenter is Mr. MC Botha. And Mr. Botha, as discussed earlier on, I am going to have to swear you in. You may then switch on your camera.
Let me just... Can you see me, Madam Chair?
Yes, I can. We are swearing you again now that we are dealing with another matter. If you don't mind, please do raise your right hand and affirm the following. Do you solemnly declare that the evidence you're going to give to this panel is the truth and the whole truth?
I do.
Okay, for the record on this particular matter, if you can please state your name, organization, and designation in relation to this particular applicant.
My name's MC Botha. I am an attorney representing AutoCast, the presenter. AutoCast operates in MADIBENG, who's the tariff applicant.
Okay, thank you very much. You may proceed with your presentation as indicated. Let's just be mindful of the time. You've got 20 minutes to present, and after I'll allow the members of the panel to ask their questions. And if you don't mind, if you can, in the interim, just share the presentation with the secretary, Ms. Lilane Jansen van Vieren.
Can you
because
please just
this,
give me the email address, Madam Chair?
it's Lelaine, do you want to come in? Lelaine dot, please do come in, Lelaine.
Chairperson, yes, it's lelani.jansenvanvieren@nasha.org.za.
Thank you very much.
Young.
I think for me, I struggled with the other one because it was not numbered. The slides were not numbered. So reference to slides when they're not numbered is quite difficult. So if I see this one as well, it does not seem to be numbered. If you can send it to her, she will share it with the members. Thank you very much.
Thank you, Madam Chair. Is the slide so visible on the screen?
It is. If you can just put it on this on a slide mode, that will be appreciated. Thank you very much.
Certainly, I will do so, Madam Chair.
It
Madam
is.
Chair, you will.
Proceed.
Thank you. You will pardon me for skimming or skipping through the introductory slides. They speak for themselves. Autocast is known to the regulator. So I'm going to focus on the more important parts of the presentation. There is a lot of demographic information, which some of it I will touch on because it's important to consider the context in which Madibeng is applying for these tariff increases. Madibeng has been dysfunctional for 15 years. It fails to pay Eskom as part of the debt relief program. It fails to comply. It has energy losses close to 50%. And the cost of its bulk exceeded the electricity revenue by 40% for 24-25. It's in breach of various financial and technical distribution license conditions. And we respectfully submit that NERSA will be and has been unable to determine lawful electricity tariffs for Madibeng, evidenced by 2024 and 26 court decisions and applications. And there's absolutely no improvement plan in place for Madibeng. Indigent users are compromised as free basic electricity in Madibeng is virtually non-existent. Shortly, why are we here today? They're unwilling or unable to improve. There's great concerns about NERSA's failure to act consistent with its constitutional duties in relation to failing licensees. And there's a repeat failure to determine lawful, pardon me, I've got something in my throat, and to take meaningful actions in relation to defaulting municipalities. And Treasury's debt relief program encourages continued municipal failures. The reapplication is submitted to be as the previous application, just a complete nonsensical, irrational application. There's no credible financial information accompanying the application. The author of the cost of supply document admits that the licensee might struggle to keep proper accounting and property records. There's no asset base for the electricity distribution, and therefore no reasonable return can be determined. There's no verifiable revenue requirement or BAU revenue as part of the application, which makes it impossible to determine a lawful tariff. There are significant errors in the bulk revenue requirement, and I will illustrate that. And the tariff decision does not reflect the outcome of a cost of supply study, which of course then would make a tariff decision completely irrational. And the cost of supply study outcome is erroneous and it doesn't reflect a realistic outcome. So the bulk revenue is substantially overcharged, and we've dealt with this particular approach under the EKURHULENI submissions as well, Madam Chair, because losses must be calculated at 12% in terms of the cost of supply framework based on sales, not based on purchases. So in that table, there's a starting point of cost of sale is per the cost of supply framework. The total energy purchases reflect disastrous losses. If you look at that, they've purchased 683 million, but they've only sold 268 million. Allowed losses based on sale would amount to 82 million. So 12% of 268 million is 32 million, not 82 million as per the cost of sale. They in itself is a 15 million kilowatt hour loss, which needs to be translated into value. Then the bulk revenue is also substantially overcharged. There are two bulk suppliers to Madibeng. The one is Eskom, which supplies, call it 90%, and the city of Tshwane, which supplies 10%. The tariff, bulk supply tariff, is R1.87 per kilowatt hour. Pardon me. And for Tshwane, it's R2.22 per kilowatt hour. However, well, firstly, as a matter of logic, accounting, and costing, the allocation between Eskom and the city of Tshwane in allowable bulk cost must be in line with actual purchases. However, in the cost of supply study bulk allocation, Madibeng includes all actual purchases from Tshwane in the allocated cost. So it multiplies the bulk purchase from 90% of its purchases with the Tshwane price, not the Eskom price, which fundamentally overstates the allowed bulk purchase costs. This slide, Madam Chair, and again, I'm not going to frog march the panel through the calculations. It speaks for itself, but it illustrates that there is a mistaken calculation. Because of the incorrect cost allocation, it amounts to 170 million rand, or 18.7% of the increase required. It's just completely overstated. Then the Madibeng's reapplication confirms that Madibeng is fundamentally overcharging industrial users. And I emphasize that this graph comes from, I beg your pardon, the application itself and the supporting cost of supply study. You will see that manufacturing industrial is overcharged by 140%, while domestic, conventional and domestic prepaid are undercharged by 100% and 58% respectively. Madam Chair, this next study also underscores why this tariff application must simply be rejected. Because the cost of supply study outcome is incorrect. If you look at the outcome that from the cost of supply study, which suggests what the charge would be, for example, for agriculture, for manufacturing industrial, and for commercial, that outcome is less than the Eskom input cost. Now that, Madam Chair, just simply cannot be. It's just impossible. It's, to put it in a different language, it's rubbish. You cannot do a cost study and then your proposed outcome is less than you paid for the electricity. So, Madam Chair, in a nutshell, Madibeng's tariff application cannot form the base for lawful tariff determination. Its electricity distribution is financially unsustainable, and it's a massive burden to the productive economy, including industry, which it is busy destroying in Madibeng. It's a massive burden to Eskom, and it is an obstacle to socioeconomic development. We therefore, as we did in EKURHULENI, recommend that Madibeng simply be sent packing and be told to do their homework and present NERSA with a compliant tariff application. We also submit that NERSA must act on Madibeng's non-compliance with its license condition and ensure that Madibeng's distribution operates under under a distribution agency agreement with Eskom. Insofar as not approving a Madibeng tariff is concerned, Madibeng and NERSA will not be left adrift. The same order which binds EKURHULENI binds Madibeng, and there will be a default position which will apply until such time as Madibeng is able to present NERSA with a compliant tariff application. Madam Chair, I hope I did justice to the limited time available, and I'm prepared to take decisions at this stage. Not decisions, questions. My apologies. Thank you.
Thank you very much, Mr. Bosa, for that presentation. I am going to be allowing the panel members to raise questions or issues of clarity based on the presentation that you have shared. And please do have a pen and paper so that you note them, because I'm going to allow all the members to come in and then you respond. And if there are follow-up questions or additional questions, I'll take them as a second round. So we will start with Mr. Majola, whose hand is up. Mr. Majola, you may come in. Thank you.
Yeah, thank you, Chair, and thanks to Mr. Porter, the presenter. For me, just one issue, and I'm actually looking at the draft record of decision that was prepared by the team for the members. So, but, and they have quoted in one of the documents the summary of comments from AutoCast. And I'll just read the first sentence of one of those paragraphs, which reads, and the stakeholder, that is now AutoCast, argues that the tariff application is unlawful because it is based on the cost plus methodology in clause 4.1a of NERSA's cost of supply framework and relies on audited information. So clearly, it sounds like there are two issues. One, it sounds like it's questioning clause 4.1a of NERSA's cost of supply framework. And secondly, it's also questioning the reliability of the unaudited information. But I don't want to get to the unaudited information part of the submission. I just want to hear from the presenter, why would they say that clause 4.1a of NERSA's cost of supply framework is unlawful? And why I'm asking this, because, you know, as I was preparing for today's session, I was also checking the founding affidavits to the court case that eventually led to NERSA's previous decision to be set aside. And after it was set aside, then we had then to come to, as we are sitting here today, to have a real look at it. And in that founding affidavit, they do state clearly there that since the promulgation of the amendments to the ERA, the cost plus method is no longer applicable. The only applicable methodology now is the rate of return. So I just wanted, therefore, to summarize just my question is, if I see here that is being said that AutoCast said that the cost plus methodology in clause 4.1a is unlawful. If you can expand on that, please. Thank you.
Thank you, Mr.
Yes,
Majola. We'll proceed to Ms. Maseti. Mr. Botha, just take the questions and you will respond to all of them. Ms. Maseti, please do come in, ma'am.
Thank you, Chairperson, and thanks, Mr. Botha. Just two questions from my side. One relates to the use of the cost that Madibeng is buying electricity from Eskom, and then instead of which is about 90%, and the other one from City of Tshwane is 10%. So I just want to check one thing in respect of that, whether from your side, you are, or your client is amenable and will be in agreement with the use of the weighted average of the two, meaning for the cost of Tshwane, sort of the City of Tshwane as well as Eskom, to use as a sort of a blended cost. Between that 2.22 rand per kilowatt hour, as well as the R1.87, just to use the proper or to use the weighted average bulk purchase price. Would you sort of be against that? Would you object to that? If that weighted average is used, and which I think it will come to a price of approximately R1.91 per kilowatt hour. That would be the weighted average of the two. And then coming to the second issue from my side, and this has to do with the part where you are stating that the industrial customers are overcharged, whilst those domestic customers are undercharged. So am I understanding this correctly? That firstly, that arises from that flawed baseline, from the the overstatement of the bulk purchase cost, firstly. And also then the way that Madibeng has followed the sort of the cross subsidization matrix, which then resulted in the higher price that punishes or penalizes industrial and mining users, for example, in favor of prepaid as well as conventional. Hence that 140% above the inverted commas, the true cost to serve the local businesses. I just want to check whether that is the grounds for that 140%, which is based on the flawed bulk cost baseline that has been used by Madibeng. Those are the two main issues from my side. Thank you very much.
Thank you, Ms. Maseti. For me, it's a point of clarity linked to what Mr. Majola raised in relation to provision 4.1a of the cost of supply framework. which he said it's unlawful. And I heard in the earlier presentation, Mr. Botha saying that they did not have an issue with the NERSA cost of supply framework. However, the issue was what was how it's being applied. If you can clarify this, because I thought for me, this point that he made in the earlier presentation, this was also applicable here. But if it's different, he can explain and also elaborate on what Mr. Majola has said. That is just my point of clarity for now. Over to you, Mr. Botha. You may be muted, Mr. Botha. We have not heard you talking at all. You may start.
Thank you, Madam Chair. My apologies. A point of clarification, insofar as it relates to the provisions of 4.1A of the cost of supply framework, and that applies throughout, not only to Madibeng, to EKURHULENI, to City of Johannesburg, and throughout the entire country, to all the jurisdictions. The legal position, the way we understand it, and that we would include all the clients I represent, is that Section 15.1 of the ERA was amended on January 2025 to clarify that it only allows for a return on assets. Previously, Section 15.1 allowed for a reasonable margin or return. Now, if you were to look at the timeline, the cost of supply framework was approved by NERSA and published, if I recall correctly, during 2023. It was published at a time when Section 15.1 was not amended and allowed for a margin or return. The cost of supply framework then has two methodologies. The one is a surplus framework, which is 4.1A, and 4.1B allows for a return. In order to calculate a return, and I think that's common cause, you need to have a regulatory asset base so that you can calculate your return on asset. I think from a cost of supply framework, it is common cause that you only calculate a return on assets. However, at a more fundamental level, 4.1A and 4.1B also contemplates the calculation of depreciation. You can only calculate depreciation with reference to a regulatory asset base. You need an asset base in accounting terms, and it's Accounting 101, to calculate depreciation. Absent a regulatory asset base, you cannot calculate the depreciation under either 4.1A or 4.1B. However, time moved on. Come 2025, the Act was changed, and the Act now only permits for the calculation of a return. Because of the change of the Act, Section 4.1A of the framework becomes pro non scripto, if I can put it that way. It becomes invalid because it contemplates a methodology which is now unlawful. And of course, and we all would know this, that NERSA cannot approve a methodology that is in conflict with legislation. If it approves a lawful methodology, which arguably at the time in 2023, when the framework was public, was lawful then, legislation then gets passed, which makes it unlawful, it automatically becomes unlawful. And there's no argument to be had to say that because it was lawful at the time we published it, it continues to be lawful despite the fact that legislation was passed which now makes it unlawful. So for that reason, we submit that using 418 to determine a tariff is unlawful simply for that reason. And our submissions here, Madam Chair, and in Ekurhuleni are supplementary to all the previous submissions we have made. We do not want to traverse and bore you with submissions that are well distilled, well made out, and which aren't remedied subsequently. So I hope, Madam Chair, it addresses the issues raised by the Chair as well as Mr. Majola. Moving on to Ms. Maseti's question about the weighted average. It seems to me, and I do not hold instructions in that regard, but it seems to me to make common sense that if you use a weighted average, as long as the weighting is calculated correctly, it will lead to a correct answer, as long as the underlying assumptions are correct. So in principle, Madam Chair, and I will take instructions and I will confirm that to the Chair or Ms. Maseti, please just guide me in that regard, whether such an approach would be acceptable. The next question was, the industrial customers are being overcharged. Where does it originate from? And is it based on a flawed bulk cost baseline? Madam Chair, the cost of supply study, which is relied upon by, I'm just trying to skip to the correct slide. That's the slide over there. That is the Madibeng's cost of supply outcome study, which makes it clear that it's vastly overcharged. Now, that could be for a number of reasons. But before there could be any realistic estimate of the extent of what the tariffs are being overcharged with, one needs a reliable cost of supply study. The information appearing in the cost of supply study is so defective and so unreliable that our submissions are that it's impossible for NERSA to make an informed, rational decision until the cost of supply study is based on information which we can all examine more closely and make a determination. Of course, the costs will reduce significantly if the bulk purchase cost is reduced to reflect only reasonable sales and not avoidable losses and the cost of that's associated with that, including the non-efficient operation cost attributable to avoidable losses. But there's no band-aid to be placed over this tariff application. And indeed, Madam Chair, there's no need to place a band-aid over it. We have a default position. It protects the regulator and it protects Madibeng. No, not Madibeng, the applicants, bearing in mind that this is historical and that the situation here has already crystallized and needs to be rectified in future as and when Madibeng remedies its own failures and defects in the tariff application. I hope that that adequately addresses the questions raised. Madam Chair, I'm happy to receive more questions if there are indeed any.
Thank you. Panel members, are you sufficiently covered on the issues that you have raised, or do you have any additional ones? If you do, please do come in. Thank you, Ms. Maseti.
Thank you very much, Chairperson. Thanks, Mr. Botha. I am covered. We look forward. I think you can submit to, they will give you the conduct details because information does not come directly to us as the members of the energy regulator that must take the decision. So they will give you the conduct details for the submission of on the weighted average of the purchase price. As the appropriate approach, given the fact that Madibeng is purchasing from Eskom as well as from a city of Tshwane. Now, just to test, there are things that you've mentioned, but for now, I just want to test the to get you under your views on the combination of cost, the way that they're extracted, even on the trial balance, combination of operational expenditure, including depreciation. Is that the correct approach without, as you indicated in your presentation, that there is no asset, appropriate asset value as required in position, position 23 or of the EPP, so that a return or depreciation can be properly calculated. So if there is no asset value, how one then extract depreciation? It is based on what calculation? I'm asking this based on the submission from Madibeng, where the depreciation is combined with operational expenditure. I would like to hear your views on that. And then secondly, as you pointed out on the issue of Section 15, talking about reasonable return or margin. So in terms of the surplus that is claimed, what is your take on that, the surplus that Madibeng has claimed that NERSA should allow a particular amount for surplus? If you can also just touch on that. And then lastly, I think you have already made mention of the issue of this net of cost of losses, linked to energy purchase from Eskom, stating that it is inappropriate. I would like, if there is, because we do have that a cost item, just to hear your approach, just so that I can be certain that the objection that you are raising and the error that you have pointed out is something that we need to take care of, because we've got two of these very same cost items of the energy purchase from Eskom, minus net of cost of losses in two items. Then you'll have an amount on the retail side as well as an amount on the wire side. What is your take? So those are the three questions that I have for you. Thank you.
Thank you, Ms. Masiti. So, insofar as the asset values are concerned, a couple of preliminary comments, Madam Chair. The licensee has various license conditions which it needs to comply with. Those license conditions include ring-fenced financial statements. It must also comply with the relevant policy positions. I don't have it before me, Ms. Maseti, but I will accept it appears somewhere in policy position 22 or 23. And in addition to that, it must also comply with the cost of supply framework methodology, which is now already 2 years old. The EPP was introduced in 2008. It had to submit D-forms, which require certain information since, I don't know I can't recall when the D-forms were introduced, but these items aren't new to the licensee. From an accounting perspective, it is impossible to calculate depreciation absent an asset base. That asset base is now regulated. So if you do not have a reliable asset base, you cannot calculate in an accounting world any depreciation, because what do you calculate it on? If you calculate it on, it's a pure fiction. That takes us to the current framework within which NERSA has decided it will determine tariffs, and that is the cost of supply framework methodology, which requires MADIBENG to submit certain information. And Madam Chair, even if we were to accept that 41A is still lawfully available to NERSA to determine a tariff, and our submissions are that it is not. But even making that assumption, you cannot allocate a depreciation cost in terms of the cost buildup in 41A. And it serves reminding that the surplus that is calculated in 41A is also calculated on the depreciation component of the cost. So if one were to try and determine a tariff plus a surplus in terms of 41A, which we claim to be unlawful, but even assuming that you were to try, that NERSA was brave enough to try and do that, it simply cannot allocate a depreciation cost because there's nothing to calculate the depreciation from. So to answer the question about what surplus should one approve for MADIBENG, A, we say that a surplus is simply unlawful for all the reasons that we have already advanced, and B, even if you were to do that, you cannot incorporate in the cost buildup that is used to calculate the surplus, be it 10% or 12% or 15% or whatever. You cannot have a depreciation figure there because that figure will be completely fictitious. The final question, Ms. Masetti, is the surplus cost over allowable losses. Of course, we have made the submission that you should calculate your allowable losses with reference to sales. So let's say you purchase 1,000 kilowatt hours, but you only sell 500 kilowatt hours. The allowable losses would be 12%. That would give you 660 kilowatt hours. That would be your allowable losses. So your allowable kilowatt hours would be 560 kilowatt hours. That will be determined as part of your energy cost. And you should then allocate that over the surplus should be apportioned over your, if I understand your question correctly, Ms. Masetti, and you must guide me here, it should firstly be apportioned over your energy cost. And I am unclear, and I will have to take instructions, but whether that also then gets allocated over your fixed costs in the same way. But one would assume that the electricity losses would still use the fixed cost component to contribute to the losses, because those losses go through to distributing electricity to consumers that aren't metered, consumers that bypass the system, etc., etc. Now, you cannot treat that as an efficient cost, because it's not. It's completely inefficient. Although it is capable of being efficiently deployed, it is inefficiently being used. So that would be the logic behind the submission, if I understood it correctly.
Thank you, Mr. Botha. Ms. Maseti, are you adequately answered?
Thank you, Chairperson, and thank you, Mr. Botha. I am answered, and we look forward then to the clarity on the issue of the weighted average. But I think also if you can carefully look into that issue of the surplus insofar as refurbishment is concerned, where the buffer would be required for such projects that are undertaken by the municipality. Just to hear your views on that, as opposed to the total rejection of it. We would like to hear that. Thank you.
Ms. Maseti, if I may ask, just to make sure that I do address your question correctly, and I think it's something that needs to be considered carefully. May I ask that you formulate the question for me in writing, and I'm not deflecting it at all, quite the contrary, so that when we respond to it, we know that we respond directly to what your core concern is, because I sense that there's a real issue at stake here, which we need to look at carefully.
That will be in order. The team will be able to put the questions that we have asked, especially in these areas. One, relating to the apportionment of the losses, not on purchase, but on sales. And also the one on the surplus. And I believe those are the two main ones. Oh, in fact, the other one on weighted average, you already got it, because there's 10% City of Tshwane, there's 90% ESCOM, and obviously at some point one needs to just calculate a weighted average so that we come to rents or cents per kilowatt hour. Thanks.
Thank you, Ms. Maseti.
Thank you very much, Ms. Maseti. Members, any follow-up questions from your side? If you have any. I think there seems to be none. Mr. Botha, I think there would be some written submissions expected from your side, and I've noted that you have requested that we capture the questions correctly for you to assist you to respond to them. And I think your submission will then be requested to be submitted to NERSA within 7 days to cover, amongst others, the issue of the weighted average on the purchase price. And as the applicant is buying from both ESCOM and Tshwane, that was raised by Ms. Maseti. The treatment of refurbishment projects in relation to the surplus to be determined for the applicant, and as well as the treatment of energy losses in relation to sales and purchases. Paraphrasing them, but I think the team will just document all of them for you and send them to you within the next day or two, and also to allow you to respond to them. And there may be other additional information that you believe you need to add such that it's brought to the attention of the panel, and that will be highly appreciated. Thank you very much, Mr. Botha, for your presentation, and I see Mr. Yadini is still here, and thanks to both of you for the presentation. We do not have any other presenters on these two applications from EKURHULENI and MADIBENG. I will therefore once more thank everyone for their attendance to the hearing, and thanking the members and NESA personnel and all the observers that are on the platform. I would like to indicate that NESA is still to consider these tariff application for redetermination from the two municipalities for the financial year 2024-25. And in considering them, dates will be indicated to all interested and affected parties and those that would want to observe the proceedings. And let me thank everyone once more and wish you a great day onwards. And the hearing is adjourned.